is up, ladies and gentlemen? We are back. We are live. It is the Freight Coach Podcast, the top podcast in transportation, coming to you guys every single weekday, 8:30 a.m. Pacific, 10:30 Central, to break down some industry headlines. But most importantly, you guys provide some actual insight into what you can do with all of this information. This is your first time tuning in. Welcome. This is the real side of freight, ladies and gentlemen. And I say that before every single show. And what I mean by that is I only speak with transportation professionals because at the end of the day, I want to talk to the right individuals who have done what you're looking to do or who are currently doing what you're trying to achieve, so you can take that information, apply it, utilize it, and see a meaningful difference in your business and your life. Happy Tuesday, everybody. I got a very special guest for you guys. I'm going to bring him up here in a minute, and we're going to break down what I think is probably one of the best takes out there in regards to the potential changes that could come down from the Supreme Court ruling out there. I know some of you in the audience are like, why do you like talking about this so much? Frankly, because I think this could fundamentally change the way that the industry is done moving forward in a way that I don't know if a lot of people are even kind of connecting the dots on. But before we do that, you guys, we're going to jump into my favorite segment, which is This Week in Freight, powered by my friends over at DAT. You guys, if you want your lane broken down on the show, email my team, podcast@thefreightcoach.com. Again, you guys, I'm just here to teach you guys how to read freight markets. All right. That's all this is. I'm not going to tell you what to quote, but there's a lot more consistency out there than some people might want you to believe. And it's because they're trying to sell you a product. I actually move freight, so I need to read these markets just like you guys to bring that stability out there to my customers. So today, dry van, Jacksonville, Florida, Indianapolis, Indiana. As always, the first thing I look at, 883 miles on that. Why is that important? This is a terrible lane to move on a Thursday or a Friday to a Monday, unless you want to pay a lot more money on that. The days of the week matter on this stuff, and you want to tell your customers about this because they could get better pricing out there if this ships Monday through Wednesday. This one, just like all of them, is up almost like $1,000 year over year right now. But again, I want you to pay attention to patterns. And this is the big thing out there because I can't control the rates, right? The drivers can't control the rates. It's just as basic as supply and demand out there, but the seasonalities remain the same, all right? Every single year, produce season affects Florida, okay? And it doesn't just affect the outbound reefer market. It affects the dry van market because there are a lot of shipments that can go van or reefer out there that when produce season hits, all the reefer capacity is gone. So it's just dry vans that are left, and they're aware of that as well. So those rates start to rise during that time as well, right? So as you can see on this nice little graph down here, rates have skyrocketed up. This is in line with the seasonality of this, right? Now, the amount that it has jumped up doesn't happen every single year, but there is a rise in pricing every single year outbound Florida for the most part, right? Like I'm sure some data guru out there could find well, in 1998, it didn't happen. All I'm saying that you guys is there is lane performances and regional performances that have not changed in the 15 plus years that I've been brokering freight, right? So if you follow up the produce belt of the Southeast, what you're going to see is it's going to creep into Georgia, then the Carolinas, and then you'll see it creep into Southern Virginia out there. And it affects all outbound freight when in regards to dry van and reefer. You see the same performance out west as well. So you need to find these things. Most customers are aware of this, but don't ever bank on the fact that you think all of the providers out there are keeping customers informed on the why this is going on in the market, what other factors are affecting capacity into there. All right. If you look at the ELP and ICE and everything, Florida is one of those benchmark states that have openly said that we're stopping every driver that comes in here. And it's just been very well documented. So that's going to affect capacity. I know that that's affected our capacity for shipments going into the state of Florida in our book of business. So those are those things that you need to talk to your customers about. But most importantly, you guys, find the consistencies year over year. Produce season affects the Southeast every single year, and it's going to. There are different varying degrees of severity on how this will increase it out there, but that happens every single year, so you need to be prepared for it. So no matter what, the spot market is your friend right now if you're not locked into any long-term contracts with your customers. And I'm going to be saying this on a lot of lanes because it is a transitionary market that we're in right now. Not every single lane out there is affected by it, but there is definite changes that are happening out there. And if you're a carrier, you're in a really good spot, right? Like, I mean, we paid a lot of money to go into Florida here this past week, and that driver is going to get a lot of money to come out of Florida. which I'm a fan of capitalism and the free market. So more power to you. Go out there and make that money. But as you guys know, bring this information to your customers. Keep them updated on a weekly basis about what you're seeing out there. Be a true transportation professional and not just a transaction. But that is This Week in Freight, powered by my friends at DAT, Jacksonville, Florida, Indianapolis, Indiana. This one's probably going to rob. It might stabilize here, but I think with the 4th of July, everything continues to rise. That's what we're seeing out there kind of across the board. If there's any hope of a stabilization factor, it's going to happen probably after the 4th of July. And also everything that's been hinging on the Iran peace deal in the Strait of Hormuz opening back up, that is going to have a big part potentially out there, right? I want to put potentially and allegedly. But all right, you guys, we are going to jump in. I got my guest on the show. We're going to be breaking down what I think is the best take out there. And I got my man, Bryan Nelson, back on the show. Bryan, how are you? You can't hear me at all?
I can't hear you, man. Yeah, I actually missed the whole intro. I heard you before. I heard the music come on. I can't hear you. I don't know if it's just me. And if you can hear me, but you kind of went in and out. I don't know if it was just me that had that issue, understanding that I'm having some tech issues.
Okay.
Yeah, I can't hear you, my friend.
Uh-oh. I hope the entire intro just didn't.
You cut in for like 2 seconds during your initial conversation, okay. And then I missed you, man.
Shoot. Okay. And are you, so you still can't hear me at all, huh?
I don't know if anyone else listening can kind of jump on and
shoot.
Let them know whether they can hear you as well.
Right. Okay. Corey Buchan says he can hear us both. So you can't hear me, but the audience can hear us. Hold on a second. All right. I'm gonna drop you down here, Bryan. All right. Let's see here. All right, guys, give us 2 seconds here. I appreciate the fact that you guys jumped in and said, let's see if we can try something else here. Yeah, we're not we're just a guy who talks shit into a mic here every single day. But I'm glad you guys could hear me out there. I could not hear you. Okay. Give me just 2 seconds. All right, we are going to pivot here because that is what we do. We pivot, and we're going to hope. Oh, there's Bryan. Let's try this. What about now, Bryan?
There we go. Hey, we go.
Now we're back,
man. Yeah. Now we're back. I'm sorry, man. That's completely on me.
No,
all right. So,
like, Bryan,
I missed the whole introduction.
No, it's all good. Here's the most important part, Bryan. The audience said they heard us both, and they heard me the whole time. So we're all good, man. I think we can we can dive in, and obviously it's been about a month since everything came down from the Supreme Court ruling out there, and I know there's a bunch of hysteria right away that happened. A lot of it unsubstantiated. A lot of opinions by people who I don't even think they know what a JD actually is, but I think now that people have had time to process a lot of this, and at first I was kind of like, damn, I don't know how this is going to shake out. There could be a lot of changes. And then I started to think about it from a risk mitigation standpoint. And then I read your paper and your post on that. And I'm like, that's the take, right? Like that's what I was looking for on there. So what was that release that you put out?
So I think after listening to the oral arguments, rereading the oral arguments multiple times, kind of focusing on what the justices really cared about, and then looking at the question actually posed to the justices on the Supreme Court, it was very kind of they did what I thought was a pretty good job of narrowly tailoring their response to the question asked, which is, does F4A preempt broker liability? And when you strip away all the other things, kind of step back and say, hey, we had a split in the circuits, right? And so for those of you who don't know, different states are organized throughout the nation as circuits. And what happens is we kind of have like our own like jurisdictional kind of heads, right? So we have, like, if we look at it from like a president, vice president, from a corporate structure, we have kind of the presidents operating as the Supreme Court. And then each circuit operates as like the, vice president of finance, vice president of legal, vice president of sales, right? And so you have all these other kind of, the circuits are all along around the country, and some circuits are made up of 3 states, some of them 5, 6, 7. There's more states involved. But the 2 circuits that were in favor of broker preemption, meaning in favor of brokers not being liable, we're talking about a total of 6 states, right? So those are the only circuits that had ruled at that level, the one level right below the Supreme Court, to say, hey, brokers aren't liable because of FAAAA. And so we're talking about, the 44 other states in the country either agreed with the Supreme Court already, right? So you had the 6th and 9th Circuit already, which is, our California jurisdiction, and then the most recent one. And you have the rest of the country kind of various points throughout. And even here in Florida started to reverse itself at the lower court, saying, yeah, we understand that the 11th Circuit governs us. We're not going to agree to that. And so you already saw cracks in the foundation, but we're talking about 44 states where nothing has really changed. I think what we lost was the opportunity from a broker standpoint. Let me be clear, not everybody was in favor of broker preemption. There's a lot of carriers that didn't like it. There's a lot of shippers that didn't like it, right? And clearly plaintiffs' counsel didn't like it. But from a broker standpoint, you lost the opportunity to argue F4A preemption. So that's one of the defenses in our toolbox are now gone. And so there is a reliance now on a reasonableness standard. And so it's not like it's not like any of our brokers out there that are listening to this said, hey, I'm only going to bid on lanes going from Georgia to Alabama because that's where I know I'm safe from, where I can argue preemption, or I'm only going to go from Wisconsin to Indiana because I want to make sure that I have preemption in my back pocket. No, you bid on freight that traveled across the entire country. And so at any point, we were always exposed to this. And so now it's just saying, hey, listen, we don't have the chance that, like I said, that tool in our toolbox is now gone. We can't use it at all. And so we have to come up with other methods. And that method is essentially where that initial fervor was about, oh my gosh, we have this unknowing duty now that we must figure out a way to solve and satisfy. And I know there's a lot of people in the industry that are working to try to figure out, what does that mean for everybody?
Yeah. And I think, so can you represent both carriers and brokers, correct?
Correct.
Okay. So to the audience out there who thinks that I only talk to people who back up brokers, Bryan takes care of all vested parties here. Right. And but like, for me, it's like, after I kind of broke this down, I think the worst take out there, honestly, is the people who are like, oh, just have a solid SOP and you'll be fine, right? Like you're immune. That'll completely absolve you from anything in the court of law. And I could tell, Bryan, people's opinions who've never been sued before, because I have been sued. And to be honest, yeah, having some of that's good, but like, what can be proven in court is very different than what you have written on a piece of paper that is in your inbox somewhere,
Correct. And I think when we have a standard operating procedure for carrier vetting, carrier selection, whatever that process is, and I will tell you that I have probably right now 35 to 40 clients that I'm working on actively on their carrier selection policies, working, and obviously the more knowledge that I have in terms of what they do and what's available to them is the more I can kind of see, hey, what's reasonable out there in the industry. Because we're looking, what the Supreme Court did, and we had the pleasure of talking the week before, right? The Supreme Court dropped their case. So, I was saying, hey, listen, I don't feel warm and fuzzy about this. I think we need to start getting, kind of prepared for what's coming down. But I think going back to what the Supreme Court said, the Supreme Court kind of talked about 2 things that really impact that carrier selection policy. And let me be clear, most of my clients already have a carrier selection policy. And most of my client that are brokers and my clients that are carriers already have safety policies, right? They have written policies detailing how they follow the FMCSRs, right? How they follow state regulatory guidelines, how they follow, hazmat certification requirements, They already have all these policies written. And now I understand that smaller carriers have to turn around and provide this, but the same way that companies come out and help them draft carrier action plans, right? Where we started to see homogenization of what those look like when there was a conditional carrier that came over and we reviewed their action plan. The issue that we're running into now is that the Supreme Court essentially did two things. One, it really threw some shade on conditional carriers.
Yeah.
I mean, what the way I describe it is they kind of like walked into a room, said something super offensive without context, and then just walked out, right? They took the plaintiff's argument and just dropped it into the middle of the opinion without context, clarification, and they just walked out. And that statement that they put in there was, hey, listen, if there's a conditional carrier, the broker knew that it was going to be, that they were going to eventually get in an accident. And that language without, qualification, anytime you use a broker uses a conditional carrier, I think there's going to be a really significant risk that language will be copied and pasted into the complaint. And that's going to be a very difficult thing to persuade a jury on that, oh, no, don't listen to the Supreme Court. They don't know what they're talking about. That argument usually doesn't fly too well in the lower courts. The second part of that is they talked about, as part of the plan, and this is where, let me kind of take a step back and talk to my large brokers and my smaller brokers. And I've had multiple conversations with my larger brokers where they've moved so far to automation that the ask in the Supreme Court in the Montgomery case that said, hey, sometimes you have to ask the hard questions or ask for a safety policy, the carrier safety policy, because they've essentially, if we take conditional carriers out there, they almost move down the requirement to where, hey, if something doesn't look right, you need to have a conversation with the carrier and you need to request a copy of their policy. And so if your carrier selection policy doesn't include language or requirement that says, hey, in certain circumstances, we need to look at the carrier safety policy, I would argue that you're not complying with the Supreme Court, but you don't have that feather in your cap to say, look, we're doing exactly what the Supreme Court told us to. We're asking for safety policies when appropriate. And so that automation, my large clients that are dealing with automation, and my carrier clients who have that document ready to provide, that they've had for years and are constantly reviewing and revising, there's no opportunity for them to provide it to the brokers to say, hey, listen, we're good, man. Like that safety rating was a long time ago, or hey, that those accidents, although they hit the number, I understand it's 2 years, but we haven't had anything in the last 6 months. Here's all the changes we made, right? So they may not have that opportunity to provide that information. But at the same time, the large brokers that have moved to automation, they're like, well, we can't scale this. We're going to have to put people back in seats of positions that we got rid of. Whereas my smaller broker clients are like, oh yeah, we're already doing that. We're already having those conversations. I already have that relationship. I've already been to that carrier's warehouse. I've already been to their facility. I've been to their offices, right? The smaller brokers that have the really personal, localized relationships, right, with customers and carriers, they're already having these conversations on a daily basis. And it's a lot easier for them as opposed to just, marking through a checkbox. And so they haven't yet established their automation. And I know that a lot of the carrier selection programs and technology out there are trying to pivot to allow for that manual process to be reinserted.
Yeah. My question for you, what is it, who's at greater risk right now if you're a carrier or a trucking company, Bryan? Because I saw 90-some%, like it might be an exaggeration, have no safety rating out there at all. So if we're going off of what the Supreme Court's saying, who is a higher risk carrier for a broker to choose? Someone with no rating or someone with a conditional rating? Because I could see an argument being made if they don't have any safety rating, why are you working with them at all? Because they have no proven track record of how they're going to operate. Is that logical, or is that completely overblown?
No, so let me kind of push back and let me give the lawyerly response here, right? It really depends on the facts of each individual case and what was known at the time and when the broker made the decision, because we're really focused on reasonableness here. And so when it comes to the conditional carriers versus the unrated carriers, let me say this: unrated carriers don't have language in the Supreme Court case that says, hey, they may be
Yeah.
likely to cause an accident. So I think from a just a jurisprudence standpoint, unrated carriers are better than conditional carriers, regardless of when that conditional rating was issued. Because that conditional rating could be 6 years, 7 years, 8 years, 10 years old. Because in the oral arguments, and let me say this, the reason why I also don't believe that the unrated should be used against any carrier is because during the Supreme Court oral arguments, the justices hammered home, and this is why some of this responsibility, right, is trying to be put on brokers, despite the 2015 case that says, all that those qualifications on the bottom of SAFER that says don't use these for safety. The Supreme Court just brushed that aside and said, no, there's not enough people here. The FMCSA doesn't have enough resources. They can't get to all these carriers, and they're not going to do it. So brokers, hey, step in and fill that gap. That's essentially what they were saying. And so when there is an unrated carrier, they're saying, hey, the FMCSA hasn't got around to it. Whereas a conditional carrier, they say, hey, the conditional carrier, the FMCSA already got around to it. Brokers, be aware. Don't ignore it. And so when we sit here and say, hey, you're unrated, well, is it because, and I would look at it this way, is it unrated because they're so new? And during oral arguments, they talked about, hey, you're going to have to answer some questions if a motor carrier is really, really new. Now, obviously, if you have a relationship, most people don't just start a trucking company without experience. Hey, I used to drive for, so-and-so, right? So you have those conversations. Hey, this driver has a, 10-year driving record with so-and-so. And, they came and started their own business, right? So those types of conversations are really easy to have. And so when you're sitting here saying, well, unrated versus not rated, unrated versus conditional carrier satisfactory, well, I would argue that a satisfactory safety rating from 10 years ago may not mean a lot if a lot of the violations in recent history have started to trend downward.
Mm-hmm. Yeah, it's
and so you really have to go ahead.
No, you go.
I was going to say, so it really is, I think we cannot ignore basics any longer, because basics are within the last 24 months, and we need to really focus on all the information given to us, because if we see the information, we have to utilize the information.
How do you think this possibly changes? Like, if you're looking at it from a shipper's perspective now, you're the one, and again, I know that this happened in the state of Texas, but like Home Depot was absolved from the accident with, I believe it was Warner. They were absolved, like, hey, they have nothing to do with that. Do you think this changes the selection strategy from the shippers? I know this isn't going to be a blanket across the board right away thing, but again, like I have been saying from the literal beginning, the next case is the one that I'm to be paying attention to more than not, because I think like the precedent hasn't been set fully. It was set on where things are currently, but it's going to be interesting. Do you think now that this makes shippers kind of change their selection, if they're going direct to carriers, if they're, obviously utilizing brokers, do you think this makes them say, hey, we want to remove any and all risk from ourselves, let's go work directly with brokers? Or if you're a carrier, you have to have all of this stuff that we're describing, you have to be able to present it. So could this potentially negatively affect the smaller fleets who don't have this stuff?
So I would say this, I think that there's going to be an adjustment period for the smaller fleets. And I think the smaller fleets, like I said, whether it's your JJ Kellers or your other kind of platforms out there that provide, training materials or sample or template documents, I think those documents, and in the age of AI, it's probably a little bit quicker to punch in things and create a formal looking policy. So I would expect that there will be small carriers, who maybe don't have the resources to engage counsel, to at least create something that looks to perhaps an untrained broker. And I would recommend that you get training for the individuals that are responsible for any type of further review process that are looking at carrier safety policies. But there is a potential that small carriers have access to resources that they didn't have 5, 10, 15 years ago to be able to provide a policy without engaging legal counsel, even if it necessarily isn't a truly accurate policy. It's not specific to the needs. It doesn't address all things. It may be enough to pass the smell test to a broker. Maybe their insurance company doesn't necessarily love it. maybe investigators if they were to get audited are like, this is garbage. But it may be enough to pass an unsuspecting or like an unsophisticated broker that's just like, oh, it's written, so I take it, right? Like, I don't care what it says. I'm just looking for something to check a box, right? And if you have individuals in your organization that view their job more as a box checker than really having a stake in the protection and the well-being of your entity and your organization, you could fall victim to getting a policy that goes, this doesn't address any of the issues that you were faced. Why did you accept this? Mm-hmm. So I think there's opportunities for carriers, small carriers, just to come by. But the small carriers, if we were to be honest, the small carriers didn't do business directly with shippers, right? So going back to your question, does this change the way shippers contract with carriers? I don't necessarily believe so, because most shippers, at least that my broker clients are competing against, mm-hmm. they're large. They have these policies. They're well-known names, if not nationally, at least regionally or locally, right? Where they have an operation and they can clearly show, hey, these vehicles are there. Now, the interesting part about the Texas case that you brought up is the decision came the day after the Supreme Court case. And I don't know, for those of you who aren't familiar with how justices work, typically every judge has a bunch of law clerks, right? Yeah. So a bunch of attorneys that are just there taking what the judge says in direction. And typically the law clerks are the ones drafting the opinions, right? Even at the Supreme Court, there's a whole bunch of law clerks. They draft the opinion, and then the justice reads over it, makes the edits that they want, and finalizes and puts their name on it and moves forward. Because I don't know if you know, judges are sitting in chambers, there's with attorneys from both sides, or they're actively in litigation going through this. So they don't have the opportunity to always do all the legal research to review all the motions and the pleadings and the filings. That's what the law clerks do. And so this was drafted long before the Supreme Court came by, and they probably didn't think that the Supreme Court case was going to come down. If they did, there's a possibility, and maybe it changes, maybe it doesn't. But I don't believe that the Montgomery case had an opportunity to impact that Texas Supreme Court case. Now, it may or may not have ultimately impacted it, but there will be questions as to its viability given the timing of it, because the judge would have, they would have done the research all before this case was done, multiple weeks. Judge signed off on it maybe 2-3 days ago before the Montgomery case came down, and then it was just automatically sent out. So we don't really know how or if the Montgomery case impacted that. So from a shipper standpoint, I think you're right. It's going to be the next case. Yeah. And then it's going to be the next case. And once you have 2 or 3 of these cases go against the shipper, I think you will see that tide turn pretty quickly to start engaging brokers as in-betweens. Now, that won't absolve shippers, right? Shippers still have their own negligence, right? Sure. They have their negligence for loading. And clearly, if someone shows up and their tractor or trailer's falling apart, looks like it's duct taped together, right? They're not going to be able to say, oh, well, the broker selected them. And especially if you're a shipper that has a fleet or has knowledge about what trucks need to be, because you're not like a shipper every so often, but you're a major shipper with, training, and these people are aware, you can't ignore what shows up at your dock. Yeah. And so I think that there will be more nuanced arguments against shippers. But if you use a broker, at least for the selection, and all things look apparently good and in proper order, I think shippers will be in a better position to avoid liability through use of a broker. And I would argue use of a broker, more brokers being used, is actually a benefit and a boom for small carriers, because they will be able to get by utilizing brokers as their customers more often than going direct to customers.
Does it muddy the waters if a small carrier is using a dispatch service now that is potentially representing multiple carriers out there? And because I'm not accusing any of these dispatching services of anything, but I have been on the receiving end of multiple phone calls where they're like, try this MC. Now I'm smart enough to be like, go pound sand. No, thank you.
Yep.
But I don't think everybody's privy to that information. How does that possibly affect things?
So I think regardless of however the dispatch service applies, and I think let me step back and say, I thought the FMCSA whiffed hard when they had the question before. Now, it was just going to be guidance and it wasn't a rule of law. But a couple years ago, when they just tried to distinguish between a dispatch service and a brokerage. And I would argue that the situation that you just aligned with hey, try this, right? I'm reminded, I don't know if you remember the movie with Weird Al Yankovic called UHF, where he bought like a small little TV station, but it was almost like there's a blind individual sitting on a park bench trying to do a Rubik's Cube, right? And every time he makes one move, he puts it to his friend, and his friend goes, nope. And he turns one more, he goes, is this it? And he's like, nope. And he just goes like, that's what it feels like sometimes when you're on the phone with these dispatch services. And I would argue that if they offer more than one MC or DOT for a specific shipment, that takes them out of a dispatch service and puts them into brokerage. And because under the information provided and presented by the FMCSA, if there needs to be no discretion whatsoever, meaning I have a carrier in this specific location to pick up this one specific load, and this is the only carrier I have no discretion when I'm calling out. I'm not going to get this load and then turn around and find a carrier, right? That's what brokers do. Or if I have 10 carriers in that location, I'm not going to go out there and then try to then sub-broker, right, and try to negotiate to find out where I can make the most margin, right? So if a dispatch service is offering multiple MCs, my concern from your standpoint as a broker, and not to mention as the carrier, I would be concerned with the carrier as well if the carrier knows that their dispatch service does this, because under the unlawful brokering regulations, if that party is viewed as a broker and they didn't have authority and they unlawfully brokered, all parties that consented to unlawful brokering activities all along the chain have potential liability, not only to the federal government, even though the FMCSA came out and said, well, we need the Department of Justice because we have no enforcement mechanism of that. So putting aside that $10,000 fine, there are obligations from an officer, director, owner, indemnification obligations for any accidents that occur or damages that occur. So we're talking cargo, we're talking personal injury. You have exposure there if you use dispatch services. But they act more like a brokerage. Now, if they truly give you, hey, I'm at today's, maybe I have a portfolio of carriers, but today I'm just giving you one MC because that's where that carrier is. Oh, that didn't work out. Cool. I'll see if I can find other shipments. That's okay from a dispatch service based on what the FMCSA said in terms of not having discretion from a load to load basis. But if they start throwing different MC numbers, I would caution you greatly on that potentially could be unlawful brokering. Will a plaintiff's attorney know to ask those questions? Probably not. Will the facts maybe muddy the water, to your point, because people don't understand the difference between brokers and dispatch services? Yeah, probably. And will dispatch services always be able to avoid liability? Probably, because they're essentially acting as an agent of the motor carrier.
Yeah, I think that is going to be the next group of participants in this industry that are going to be regulated a lot sooner than a lot of them even want to comprehend. I think now, Bryan, where it's like, even if you're an acting sales agent for the carrier and finding direct freight for the shipper, I think you are going to be brought into this. You are going to be federally regulated, because I just don't see a world anymore where there's anybody who can get away with flying under the radar on any freight transaction. Because again, unfortunately, people are killed on the freeway all the time by semi trucks. I think some of these cases are going to be happening a lot faster than a lot of people think. Now that this ruling has came down, I think any court, and again, I'd like to get your opinion on this, and I know we're a little over on time and we can wrap with this. Any case that's under appeal now probably fundamentally changes. And now any case that is currently under investigation and in the due diligence phase of all of it is going to be fundamentally changed now. And so some of these rulings are going to come a lot sooner. And do you think that puts pressure on the FMCSA to start making changes to the dispatch services and anybody who's involved in this freight transaction?
3 points to that. And obviously we had tech issues starting, or I had tech issues starting. So let me again, thank you for having me on here. I always love these conversations. And this question, I think, is threefold. One is, I don't think the FMCSA can chew gum and walk at the same time. Yeah. And right now, the major focus is on broker selection criteria and memorializing what duties there are from a federal level from brokers. I think that still remains the primary focus. Would they be able to push forward legislation regarding dispatch services? I don't believe that that's going to be in their purview while this Montgomery case is so fresh. The
Yeah.
second part of this is that the ruling, unlike a new law, this is a Supreme Court ruling detailing the interpretation of the law and how it should be interpreted. And so, to your point, if you had an accident from 3 years ago that hadn't been litigated and either settled or resolved in some manner, either through the entirety of the litigation process or through settlement and resolution, the complaints are going to be amended. The settlement negotiations are going to change significantly. And if you have your contingent auto policy, you're going to stay in the litigation longer because instead of, hey, the complaint gets filed, an answer gets filed, and then you're immediately filing a motion to dismiss based on FAAAA preemption, that's no longer available. So we're going to have to stay in the case longer until either, summary judgment's appropriate or there's, an ultimate settlement somewhere else along the line. And then third, the last thing I want to say here is if we find ourselves in a position where there are, I guess, more and more actions against brokers, which we know there's going to be, we are going to find ourselves a little bit more knowledgeable in terms of where the settlement ranges go. And so, we talk about, insurance companies talk about, oh, well, insurance rates are going to go up. But we're talking about defense costs because if I'm insuring a small broker and I have $1 million in coverage, I knew what my exposure was. It was always going to be $1 million, right? I knew that coming in. I knew in 44 states out of the country, I knew that I was probably not going to be able to get out on summary judgment. So there's always been this, hey, I have $1 million, but at least I know as an insurance company, my liability is capped. And for those large brokers that have more than that insurance, right? They have 5 million, 10 million, 20 million, 30 million, 40 million, whatever they are. If there's a over limits case of $10 million over whatever they have, it's a lot harder for large brokers to shut down because the argument would be, well, they have more money, they have more resources to withstand that and continue. Whereas if a small broker gets that, I'm closing down.
Yeah.
In addition, if I'm closing down, you know what there isn't a phrase for? There's no phrase for chameleon brokers.
Correct.
I can turn around, I can start a new brokerage without any regulation whatsoever and immediately start doing business tomorrow. And guess what? The FMCSA isn't going to take any type of violation because, oh, that's right, brokers don't typically get, violations. They don't get penalties provisions enforced by the FMCSA. So there are opportunities immediately for a small broker to say, yeah, that's okay. If it's just me and like two other people, my two other people will be like, yeah, cool, I'll just move with you to the next business. And so from those three things, I think portability of business, right, from one entity to the other is better with small brokers. Going back, I think we have to look back to any accident that you had that hasn't been resolved yet within the statute of limitations. Any broker, there's going to be a new charge, right, or at least reinforcement of that charge. And I think that's it. When it comes to the dispatch services, I don't think we're there yet.
Yeah. Sounds like it's a great day to be an attorney in this industry. A lot of billable hours coming down.
Oh my gosh.
No, man. I do appreciate you coming on here and breaking this down. I think that we're just inundated with the wrong information out there. We're inundated in a society where people want to be first to put information out there. And unfortunately, people make decisions for their business based on what they saw on fucking Twitter. And it's like, I just appreciate you coming on here and breaking this down from a carrier and a broker's perspective, because you represent both. And ultimately, all of this show is designed for you guys is to help you guys think a little bit differently. And then, but again, rest assured, the guys who I have come on this show actually do the job that they're talking about, right? Like Bryan is a pretty face, but he's not just here to talk about what he would do if he was an attorney. He is an actual attorney. So
I appreciate it. And Chris, I love the work that you do. I try to catch as many of your segments as I can, because you know what? When I'm driving to work, it's a perfect thing to listen to. Coming out, it keeps me educated. So I really appreciate all the work you do. And thank you for including me as often as you do. It's always a great conversation. I know we could keep this going for another 3 hours if we wanted to.
Well, perfect, man. Bryan, thank you so much for your time. That's going to be it for today, ladies and gentlemen. As always, if you got value in what you heard and you're not subscribed, subscribe to the show, you guys. And if you're feeling ambitious, rank it on iTunes and Spotify, because if you see value, your network sees it as well. I appreciate you guys. I love you guys, and we'll be talking to you soon.
Came back with a bang, window down, yelling out money, anything. Hey, ooh, got the foot on the gas, pedal to the metal when I'm getting to the bag.